Before I get to my stuff, are there any questions or comments? Questions, comments, concerns, whatever the case is? Okay, so I want to just talk about something real briefly here. There's actually a good forum question about this, and it's the passage of years in questions. This is an easy problem to overthink. So in exam questions or scenarios or whatever the case is. Okay, and I'm going to use actually the fake Melanie scenario. Okay, so fake Melanie started work at age 26. She's retiring at 58. Okay, everybody's with me here? That's all true, isn't it? Assuming that her crystal ball is functional and she really does retire at 58, but let's go with that. Okay, that's 32 years. And that's going to be the same for any question like this, unless you're given a set of dates, okay? So if you were told, so if you were given dates and it looked something like this, that, I don't know, whatever, she started work, oh, how are we going to do this? So she retires, excuse me, let's say 1 Jan of 2000 and, what are we going to be here? It's going to be 30 years from now, so 2050. So she's going to retire 1 Jan 2050, and she started work on 30 December or whatever it is. Okay, thanks, Rose. Yeah, and she started work on 30 December of 2018. Okay, you with me here? Then that's not 32 years. Okay, that's really 31 years. But you'd have to be given so much information. Do you see that? So when you see age 58 and age 26, you just subtract the two numbers. Is everybody with me there? Don't overthink this. And this is where students get themselves into trouble. Okay, to get this, some other figure other than 32 years, you really have to make a lot of assumptions about what happened at age 26 and what's happening at age 58. Okay, now I will point to one slightly different scenario for Income Tax Act purposes. If you're dealing with something that is explicitly related to the passage of time for tax calculations, and the best example of this is the principal residence exemption. Okay, here any portion of a year counts as a year. So for the principal residence exemption, you buy a house. She did start 2 years back. In that exact case, she started 2 years back. That's still 2 years, Todd. It doesn't change anything, right? It's still 2 years. Okay. So for Income Tax Act purposes, you buy a house in, let's say, November of 2010, okay? And you sell the house in May of 2020, whatever the case is. Is everybody with me there? You owned that house in 2010, 2011, 2012, and honestly, on the exam, if you had sat beside me the day that I wrote my CFP exam, you would have seen me counting years on my finger like I was in grade 2. Fingers, I guess I needed to use 2 hands. Okay, everybody with me here? I would have counted this out just like so. I know it's tedious, but I don't want to get it wrong. That is, and if you count on your fingers with me here, 2010, 2011, 2012, 2013, 2014. I have 5 fingers in the air right now. 2015, 2016, 2017, 2018, 2019. I have 10 fingers in the air. I add 1 more finger. I'm at 11 fingers. That's 11 years of ownership. Okay, I'm not talking about the formula here, Mark. Okay, I'm not, all I'm saying is that is 11 years of ownership. If I'm counting years, it's 11 years. Okay, we'll talk about the principal residence formula in advanced curriculum. We don't need it here. We'll do it when we need it. Okay, but that is unquestionably, according to the Income Tax Act, 11 years of ownership. Is everybody with me there? Does everybody understand the difference between the 3 sort of different scenarios, or 2.5 different scenarios that I have laid out here? Okay. Yeah, and I think honestly, Mark, this is like a lot of things that we do to ourselves when we're writing exam questions. We trick ourselves. Okay. I see age 26 and 58, and I think, oh, what if she started in December and retired in? No, that's not it. It's 32 years. Good. Okay. I hope that's clear as day. Perfect. Okay, do you have any questions for me? Questions from the floor? All I'm doing, Mark, is because the 26 to 58, that's like years of life, right? So how many years pass from age 26 to age 27? If I just ask you that question, 1 year, right? So how many questions pass from, or how many years pass from age 26 to 28, right? Then it's 2 years. So from age 26 to 58, it's just 32 years. Okay. Now, Mark, if I'm given the dates, okay, I showed the dates. If I'm given the dates and I have some reason to count it differently, great. Okay. But if I'm just doing a time value of money calculation or a pension benefit calculation or anything where I'm just counting years, then just 58 minus 26. Good. Okay. Don't overcomplicate this. Plenty of complexity here already. We don't need to add any. All right. Okay, and I would be surprised if you're given dates for a 32-year scenario like that. Where you might see that kind of thing would be in a 18-month scenario or that kind of thing. If it's more focused on the shorter time frame, then the dates become potentially quite relevant. Okay. So we are on the last of Unit 5 today. We should get it done or close to done today. I think we'll be okay. And then when we start off next week, we're together again next Thursday, we're rolling into Unit 6, okay? And I like Unit 6. I'm considering doing something a little bit different for the 17th of September when we get into some, actually, sorry, the 24th September when we do some case study stuff. That's right, isn't it, Todd? September 10th is next Thursday. So yeah, and that puts us into the last unit of core curriculum. No, this is right, Rose. This is right. Yeah. Okay. I changed, Rose, I don't know why you don't get these changes. I don't understand how to get this happening. I changed this about 3 months ago, Rose. Okay. All right. I don't know where that came from, Todd. I'm not sure what communication. Yeah, no, I understand what you're trying to say. I don't know what communication instigated that. Yeah. Okay, we definitely have class on the 10th of September, okay? We 100% do. That's the same I showed last week, right? Okay, yes. Okay. Right, but the long weekend is well before then, right? Yes, no break. That's right. Okay. No, we didn't change that, Paul. Remember when Penny came on, I said, I'm not sure we're going to change, and we didn't change that. It is definitely the 24th. Okay. I am not going to Vancouver. All right. You taking the whole week off, Todd? I got it. All right. I'm not sure what communication there might have been that might have been confusing here, but this has been our schedule for quite a while. Okay. All right. Okay. I mean, you can do class from anywhere, Todd. Take your vacation and do class from anywhere, right? Melanie can vouch for that. All right. So, okay, perfect. Same schedule as per. Okay, so yeah, that's an option too, Todd. Yeah. Okay, so gift over provision. So we left off last week having looked at some of the challenges that can arise in a will. We started off with just a discussion around residue, devices, bequests. What's a device? If I use that word device in this term, in this context, what does it mean? Uh-oh, anybody remember that from last week? A device? Nobody wants to throw in here? There we go, Bev, thanks. A device is a gift of real property, okay? So if you have the family cottage or the house or an apartment building, those are all devices, okay? If you're going to leave that thing intact to a family member, okay? That's good. Whereas if the estate is going to sell the cottage and just distribute the cash, then that's not a device. That might be a bequest if it's specific amounts of cash to specific people, or a residual distribution. Hey, look at that, Bev. All right. Bev drags out the 25-cent word here to start the day. Yeah, so because that would be the switch there, Bev, right? If you sell the house, you convert it from the house being a non-fungible asset to cash being a fungible asset. Okay. That's good. So normally, Stephen, that should have been addressed in his original separation agreement. Has she been on the plan for that whole 10 years? That would be the first question I have. Okay. And are you talking about your group life, like extended health and dental? You're not talking about a pension here. I'm talking about a group RRSP. You're talking about health and dental primarily? Yeah. So she should have come off the plan. Typically, plan sponsors will say something like, we'll keep an X on the plan for some period. It's usually 30 or 60 days. So 10 years is well past what would be normal here. I have seen as long as 6 months on an exceptional basis. I've seen it where the plan sponsor, if they get an explicit request to do so, will sometimes allow an X to stay on the plan for as long as 6 months. Okay. But after that, no, you shouldn't have that person still on the plan. If you do, then I don't know, you might have a little bit of a challenge with the carrier now. If somebody goes and says to the carrier, hey, he's actually been, and it's not divorce, right? It's separated would be the question. He's been separated for whatever, 10, 11, 12 years, and you've been covering that person that whole time. I'm not exactly sure how the carrier is going to address that. Now, it shouldn't actually be that big a deal because by extension, that person would have been paying a family premium, right? They weren't paying a single premium. They would have been paying a family premium. So it shouldn't be that big a deal. But it's one of those things that really should be sorted out in your separation agreement. Okay. All right. Okay. We'll see you back in 15, Melanie. All right. Okay. So gift over provisions. So this is what addresses the following question. So let's have a similar scenario to what we had last week. I don't remember the name of the lady that we had last week, but I have Elaine here. She is age 73. Okay. She is a widow. And she has some assets. Okay. Let's say for the sake of argument, she's going to have, just because NICs are $600,000 of estate value that's going to be distributed. Okay. That's good. So she's going to die in our scenario. And Elaine had 3 kids. Okay. So she's got, I don't want to use Jeff here. Jeff on the call. We're going to have John, Karen, and Lisa. Those are her 3 kids. Okay. Everybody's with me here? Now, as it happens, her intention here, she named each of the 3 as residual beneficiaries. And she was planning to leave them 1/3 each. All right. However, Lisa has predeceased Elaine. So one of these tragic situations, your child dies before you do. Okay. Yeah, she had a will. That's the only real way that we're going to get a residual distribution. Like this probably could happen through an intestacy, but we'll say she had a will. Okay. So, all right. So then Lisa has predeceased. So now the question is, without Lisa here, what is going to happen to the gift that would have been left to Lisa? Okay. So let's say, for the sake of argument here, that the language in the will is each of my children gets 1/3 of my estate. Okay. Or what she might have done is an equal proportion. All right. So with no other language in the will, what's going to happen here is essentially John and Karen will benefit from Lisa's premature death. Okay. So with no other language in the will, nothing is left to Lisa. We would say any gift to her would lapse. And lapse, again, is a specific legal term that means a gift that was written in the will does not end up happening. Okay. Does that make sense? However, it is pretty common with a, right, so there we go, Nicole. It's pretty common with a lawyer drafted will. If you get a good will done by a lawyer who does a lot of wills work, okay, it would be pretty typical to see something like this. A gift over provision. And the gift over provision says, yeah, he's in, Paul, he's in. Okay. The gift over provision says that if we have a situation where this would lapse, then we're going to essentially go over Lisa to the next generation. Now, there are 2 kinds of gift over provisions. And to illustrate this, there you go, Carla. To illustrate this, I'm going to give Lisa some kids. Okay. So Lisa has, let's say, for the sake of simplicity here, she has 2 children of her own. We've got Mike and Norma. Okay, that's good. So now there are 2 possible kinds of gift over provisions. We could have a per capita distribution. In a per capita distribution, everybody is going to be treated equally. So in a per capita distribution, there is no regard for what generation somebody is. You have 4 heirs. Okay, we got John, Karen, Mike, and Norma. Each is going to get 1/4 of the estate. So they're going to get $150,000 each. Okay, that's good. Or my alternative here is we could have a per stirpes distribution. I think per capita is language people are generally comfortable with, right? How many, whatever, physicians are there per capita, or what's our GDP per capita? We know that that's per head, per person, that kind of thing. Per stirpes is a little more complicated. Stirpes is the veins in a leaf. It's the Latin term for the little veins in a leaf. I'll show you that right away. So in a per stirpes distribution, each branch stays intact. So what happened here is John and Karen each get their $200,000, and then Lisa's $200,000 branch stays intact. And then the result would be that Mike and Norma get $100,000 each. Okay, so that is the effect of that per stirpes distribution. Now, if you don't have any gift over provision, then Mike and Norma will get nothing. That's good. So if the lawyer or whomever didn't draft a will properly, or maybe intentionally we didn't do this, but with no gift over provision, there is nothing for Mike and Norma. Is everybody good with that? Now your intestacy rules, so if you die without a will, and this goes back to the comment that Paul had made, if you die without a will, the intestacy rules will have whatever the default gift over provision is. So in some provinces, there would be no gift over in an intestacy. In some provinces, there's a per capita distribution on intestacy. And in some provinces, there's a per stirpes distribution on intestacy. And that's really just a matter of how that particular province drafted its estate legislation. That's good. So that's your per stirpes, right? Each of those little branches in Latin would be a stirpes, okay? I don't honestly remember, Nicole. If you're asking about intestacy, I do not have an in-depth remembrance of every province's intestacy regime, sorry. It's such an obscure bit of detail, honestly, okay? It's the kind of thing that hardly ever comes up, because look at all the things that have to happen, right? First off, you have to die without a will. Second, you have to have enough property to actually, for this to matter. Third, you have to have a child who predeceased you and had kids of their own. Okay, so well, that's interesting. So it does happen, obviously, Nicole, and the grandkids got the grandma's amount, or their mom's amount, I guess. Sorry, right? So yes, then that's probably a good assumption that it's per stirpes in Alberta. All right. Okay. No. So Bev, this is where you get into, now, okay, you could have written your will in such a way, right? Keep in mind that nieces and nephews, Lisa's nieces and nephews are John and Karen's kids, right? So they would already presumably be taken care of by John and Karen. Okay. In estate law, we have this concept called lineal ascendancy. Okay. So lineal ascendancy says that we are generally only going up and down the line with respect to a gift. Right, Lisa's husband would have no default entitlement to anything here, Todd. Now, if the language in the will specified, so this is where we have to look at what the language in the will said, because the language could say Lisa or her heirs and successors, okay? And that could end up with her husband if she died with a husband. The challenge there is that very generic heirs and successors language is hard to interpret, right? What if she had a husband when she died and he has since remarried? Is he now her heir and successor? And this is where it gets really messy, Todd, right? So yeah, you generally want to specify, and that's again the value of an estate lawyer who does this work all the time. You want to make sure that you think about all those possibilities. Okay. So yeah, lineal ascendancy goes like this. It goes grandma and grandpa, and then mom and dad, and then the grandkids, right? So it's only a straight line. I guess I do the kids here. Whatever, right? So it's only a straight line like that. We're not pushing out to nieces and nephews. Now, Bev, sometimes you can get an argument that a niece and nephew was really in a childlike relationship. So if Lisa was raising one of Karen's kids because Karen wasn't able to do so, well, that gets a little bit messier. Okay. Yeah, exactly that, Grant. And again, that's where an estate lawyer who does a lot of this kind of work and has run into the types of scenarios that Nicole references, that person is going to write a better will than what you're going to get with just a will kit or a lawyer who doesn't do a ton of this kind of work. Okay, and some of that, Grant, ties into the client's ability to realize that their life is not so simple, right? This is very common. People sort of make this default assumption that my life is not complicated and nothing in my life has a potential minefield in it for anybody else to deal with later on, when the reality is we all have those minefields. Okay, that's good. The vast majority of you on this call have it just because you own a business. Okay. Yeah, now what should, and I mean, that's good, Nicole, it's a terrible reason to have it, I get that, right? But what should happen is your will, even without having gone through all that stuff, a good will is going to contemplate all of those puzzle pieces, right? And you can see now where it goes wrong if you don't have a will that contemplates all of that. And you've got, I think you have a farming interest, Nicole, right? You've got real property, you've got ownership in a business. So all of those things just add to that complexity, right? Okay. Yeah, so this is a true story, Shauna. This goes to, unfortunately, it's actually something we're not going to talk about until advanced curriculum. I am going to show you how to solve that problem. You remember last time we're together, I briefly mentioned, Shauna, the mutual will. So that's a solution that people have tried to use in the past for that problem. They would have written a mutual will that says, if I die first, you still have to take care of my kids with the money I leave behind for you. That's not been a terribly effective solution. What we'll see more often, and I will show you this in advanced curriculum, but we'll see more often is the use of a trust to address that problem. And really with the trust, you're bypassing the will. Yes, Paul, exactly. Or at least it should be contemplated. So again, the lawyer is not going to say, should we include a gift over provision? You with me here? The lawyer is going to talk through this scenario. The lawyer is going to tell the story about Nicole's aunt and say, you know, if that kind of thing happened, how would you want it addressed? And then the lawyer will match the language up to that. But you're not, ideally, in a conversation with the lawyer, you're not going to hear the words gift over, per stirpes, or per capita. That's good. All right. Okay, any other questions on gift over provisions? Okay. Oh, sure, Melanie, yeah. Okay. Yeah, no, I saw that, yeah. All right. Okay, so this issue came up previously, and this is the question of where do I keep my will? Okay, where is my will? Now, why this is a concern is a couple of things. First off, we need an original copy of a will, usually notarized, for the executor to be able to start doing the executor stuff. Okay. We also have a concern where if you have lots of copies of your will floating around, it can be confusing. The issue here is that we typically, if I'm writing a new will, oh, on that note, actually, Todd, I'll come back to a comment you made last class. So when I'm writing a new will, okay, I have to destroy any old wills. Now, technically, I don't. I 100% need to make sure they're all destroyed, but the presence of old wills can create confusion. So what'll happen sometimes here, sometimes somebody who's named in the old will will use that, they'll use the old will as proof or as evidence that this was your intention, that your intention was different than what's in the new will. Right, so the same would apply to copies, Todd, and that's where I always am cautious with financial advisors taking copies of their clients' wills. I think it's perfectly fine if you're writing a financial plan for somebody to get a copy of their will, but you should have, in my opinion, in order to preserve your own business, in order to also limit your client's liability, in order to limit your own liability, you should have a destruction policy with that will. So you say, client, I'll take a photocopy of your will, but I'll destroy it after 3 months or 6 months or whatever, some time frame like that, right? Okay, I just want to take a second. We're going to deviate for a moment here. We'll talk about BC. So BC, just like Alberta, so in 2014, BC updated its Wills and Estate Succession Act, WISA, and it has a lot of good modernization in it. We talked about the fact that, for example, in BC, you don't destroy, so you don't wreck a will by getting married. So wills in BC survive getting married, unlike in other provinces, except in Alberta, where they also survive getting married. But one thing that this legislation says, and this is what you had commented on last time, Todd. So the legislation says a will drafted outside of British Columbia is not by default going to be accepted in BC. So really that means the courts have to see the will in order to accept it. And that's where typically they will, okay? However, it is something to review. If you have a client who relocates to BC, it's not a bad idea for them to go sit with an estate lawyer and review whatever will they have. Okay, but it's not to say that wills normally get rejected. In fact, wills normally get accepted under this provision, but we should not assume. Okay, that's fair. So I did look that up, Todd, after we chatted last time. All right, just pop back to will storage and destruction. And we're going to talk about BC here again in a moment, which is what prompted me to bring up that point. So this is where you get this kind of this challenge with how do I make sure that there's going to be a will without having wills everywhere? So the concern here, if I have a will in my house, okay, so I have a will in my house and that's where the will is. If I die in a total loss house fire, there is an assumption, the law assumes my will burned up with me. Okay, and that's sort of the morbid assumption that goes along with this, that if you have a house fire, so that's where you get the whole idea to store your will in your freezer, in your deep freeze, right? I'm sure some of you have that kind of thing. What I will say about that is I've heard mixed things about this from people who have experienced total loss house fires. What they generally say is that your freezer will burn, it will just be the last thing to burn, okay? Same comment about fireproof safes. Fireproof safes are fireproof, but they're not necessarily heat proof. Basically, all that has to happen is the internal temperature on the safe has to reach 451 degrees Fahrenheit, and then the stuff inside the safe will ignite, right? Okay. So that's what some people do, Bev. They'll use the safety deposit box. I'm going to pick on the safety deposit box here too, as you might have guessed. And the problem with the safety deposit box is that only an authorized person can access it, right? Okay. So, well, hang on to that thought, Paul. I don't have a perfect answer for that, as you might have guessed, okay? So only an authorized person can access it. So the executor is an authorized person. You with me here? But the proof that they're the executor is in the safety deposit box. Now, this is where if the bank manager, well, if that person has a copy, okay, so I'll suggest some things here, Nicole, and it's like a lot of other things. It depends where you are, okay? So it depends on your circumstances. Right, so that's something they should have, Bev. They should have a copy of it that they can present to the bank manager and say, now would you let me in? Even with that, Bev, I have seen it where the bank manager would not. Okay. I like it, Stephen, with a treasure map. So you give your executor a treasure map so they can find it. Okay. Yeah, you just need some sort of evidence that person is the executor, Tricia. Now, to be fair, Tricia, I have generally heard this complaint at big city bank branches and less often at rural bank branches and at credit unions. Okay. That's good. Okay. So that is potentially an option. So if the executor has a copy of the will, that's helpful. And I have seen this get better in the last couple of years. This was a legitimate problem that I was seeing more of back in about 2015, 16, thereabouts, where people couldn't get into their testators' safety deposit boxes. So that's good, Todd. Yeah, that would make that person an authorized person as long as you set up the ownership properly, right? So that's where you have to make sure that only one person has to be there to get into the safety deposit box. I kind of agree with that, Jordan. However, there is no province that allows electronic storage of wills today. So there's no cloud solution. I'll show you that one right away, Paul. We'll talk about that. Okay. Now, I'm going to give British Columbia kudos here. British Columbia is the only province that has this. Okay. So BC has an electronic wills registry. And I can't remember what it costs, either free or very close to free. It's like a negligible cost. Okay, so Esther, yes, you can do that. You can give your executor and all named beneficiaries a copy, but go back up to my top comment here about having many copies of your will floating around. Okay, if you know you're never going to change anything in your will, that's fine. So yeah, BC has an electronic wills registry. You still have to store your will, but you can register to indicate where it's stored. And that to me is a good practice. I like that. I wish that that was something we had nationally. Okay, what about with the lawyer? Paul, some lawyers still do this, right? So the law office might keep a copy of the will. Okay, and in fact, I have this. So my lawyer, and I'm not suggesting this is right. I'm only telling you this is what I have. Okay, my lawyer still has a copy of my will in their archives, and then I have a little card in my wallet that says if you need my will or my power of attorney, they are stored at this law office. Okay, and that way somebody can go get them if needed. Now that being said, yeah, and that's not something I came up with, Janelle. That was my lawyer, who was somebody who did a lot of wills work, right? All that good stuff. So yeah, the law office might keep a copy. However, fewer lawyers are doing this because they have gotten themselves into some trouble here. You have lawyers now storing thousands and thousands of wills. It's very expensive. It's an insurance problem. My CGL folks, what are you going to do to insure a warehouse full of old paper? What kind of risk is that going to be, Shauna? And a warehouse full of old paper that is of quite a high value, right? Literally irreplaceable documents in some cases, right? Okay. Yeah, I've often thought about this, Paul, about how to do this. Honestly, if there was cloud storage, it'd be so much better, but we don't have that. So yeah, very expensive to do this. And the other problem here is you can't just decide to destroy old wills. You've made this commitment to your clients that you're going to keep their will. You can't just arbitrarily say, well, we've had that will for 20 years or 50 years or whatever the case is. It's time to destroy it. That's good. Nice, Grant. All right. Okay. Yeah, I don't know if anybody ever worked in a law office before. I like I will, Grant. That's good. Yeah. you ever worked in a law office, you would see this. The document storage and document retention is actually a big part of the sort of secondary business of law firms. Okay, so what I'm going to suggest is when you get your will done, you get 3 notarized copies. I like 3 notarized copies. It's not a crazy number. It's enough that you can keep track of them. Okay, and you keep one in your house, one with your executor, as long as it's not also your spouse or your alternate executor. Don't keep 2 in your house. That doesn't help anything, right? And then one with a beneficiary or some other third party. I actually keep, or I used to, now I don't have a desk drawer, but in your desk drawer at work is not a bad idea. Okay, something like that, where there's a third copy of it somewhere else, but not to have 10 copies or 15 copies of it floating around. Just a clear, yeah, there you go, Nicole, right? Yeah, I don't think people think about it that much, Paul. In reality, though, a good estate lawyer is going to talk to their client about this, okay? They're going to say, look, now you're going to have these documents. If you're ever going to replace this will, you want to make sure that you have the ability to do so properly. And that's going to include things like not having 100 copies of your will floating around. Okay. Now, it doesn't surprise me, Paul. In Cape Breton, I think you would find most lawyers are still retaining copies of wills for their clients. I'm sure that that's the normal practice. Yeah, notarized, Bev, yeah. And that's when the lawyer writes the will, Bev, they will notarize a couple copies for you. Okay. Yeah, I do think so, Paul. But, you know, transform that or translate that into downtown Vancouver, where real estate costs are significantly higher than in Cape Breton, right? And where you're going to run into more problems with liability exposure. There'd be other tenants in any facility you're using. You know, if you're using warehouse space, it's still fairly competitive there, right? So that's where you will find a lot of regional differences here. All right. Yeah, and it's a big difference, Paul, right? From Sydney to, let's say, North Van, as to how this is going to look for the ability to store that document. Okay. Any questions there? I think it's a discussion you can have with your own clients. I think it's an interesting discussion. It's something that if you're figuring out whether or not a lawyer you're using is having a robust conversation with your clients, I think this is a good question to ask after your client meets with the lawyer to say, hey, what did you guys talk about for will storage? Where do you have copies of your will? Okay. All right. That's all good? Yeah, that's really good, Grant, right? That's going to make that executor's job easier. Okay. There you go, Shauna. Yeah. All right. Now you can go get a photocopy and then get it notarized afterwards if you want. But yeah, if that's the only copy of your will is the one in the lawyer's office, that might be some risk, right? Okay. All right, codicil. I think this language came up briefly before. So a codicil is simply an amendment to a will. It's hardly ever done. You'll hardly see anybody actually use a codicil today. It really was more popular in the pre-word processor days. So whatever, Microsoft Word or Word Perfect, whatever word processor you started off with. But pre-Microsoft Word, this was far more common. Today, most lawyers will just rewrite the will when you're doing a codicil. It's not really any different. The issue here is doing the codicil probably would be just a tiny bit cheaper, but you could very easily run into a problem where there's an inconsistency between the will and the codicil, and that's not necessarily helpful then. Okay, so lawyers will just say, look, don't bother. We're not going to do a codicil. We're just going to take the whole will and update it. Okay, nice. Great. All right. Okay, so the codicil has to meet the same form as the will. So the whole signed, dated, witnessed thing. Okay. Yeah, exactly, Paul. A major change like that is exactly a circumstance when you should just be updating your will. Okay. And I have a section in chapter 15 that suggests the different times when it's worth it to get the will reviewed and then possibly updated. Okay, that's good. Now, where you will see a codicil used, and some of you might have had clients who've had this happen. So for whatever reason, this is what lawyers get. This is what happens. People don't think about things until it's too late. So you have a client who maybe either got married or started a common law relationship, whatever, let's say 10 months ago, okay? And now they're going on a big family trip. And it's with the new partner and the kids and the whole works. Everybody's with me here? And for whatever reason, this is when people figure something's going to go wrong. So 3 days before they leave, they call the lawyer and say, I think I need a new will. Okay. And the lawyer says, yeah, you're probably right, but I don't have time to meet you in the next 3 days. And even if I did, I wouldn't have time to do the full investigation that we need to get you a proper will. That's good. Everybody's with me there? And so the lawyer says, look, I can't see you today, or I can't see you before you leave. So take out a piece of paper, write down what you want, and sign it. And what you've essentially created now is a holograph codicil. Okay, and this is a legitimate thing that lawyers will do. And then come and see me when you get back. And it won't be perfect, but it'll be better than if you just kept the old will and I just can't get you in before your departure to get your will sorted out. Okay, anybody had that experience? It's actually, for whatever reason, a relatively common thing. Every estate lawyer has this exact story. Okay. Okay, perfect. Okay, so then if we want to, So that, again, Paul, that might be a time to revise your will, right? I don't think that that's a codicil situation. Really, the only thing that requires the codicil today is when you need a change done on very short notice. Now, I guess if you're going on the family trip with that son who's in the rocky marriage, maybe then. But really, that's where you want to think about what that whole set of gifts look like, right? Okay. Yeah, that's just a time when that person should be going to see their lawyer to get everything updated. Okay. All right. Are you having internet problems, Melanie? I see you've been off and on a couple times this morning now. Okay. Perfect. All right. So what happens here sometimes is, oh, okay, funny. So the, you don't mean you're sitting in Tim Hortons all day to get internet, are you? Okay. Hey, I did a class once. I did a whole class, Melanie, from an en route, from the en route just outside of Cambridge, actually. So, oh, that's brutal. All right. So the, nice fall. I don't know if she's delivering. So, so when you have, sorry, beneficiaries or heirs or family members who are dissatisfied with your will, they are going to try and find a way to challenge that will. Okay. Honestly, if you die and you leave behind an estate that keeps everybody happy, there will be no challenges here. Okay. But if there's somebody who didn't get what they thought they were going to get, they're going to look for ways to challenge the will. Does that make sense? So one of those sets of challenges could arise because they're going to claim that it wasn't really you who wrote the will. So in general, to write a will, you must have capacity. Now we'll talk about that in a moment. Okay, which really means you have to understand that you are distributing your property and the consequences of that distribution. Okay, does that make sense? Is everybody with me there? So that means that if you have a potential beneficiary, somebody who feels they should have gotten something, and they want to challenge your will, they'll say, look, either mom, dad, grandma, grandpa, whatever the case is, lacked capacity. So they didn't have sufficient capacity. They didn't understand. Okay. And this is a fairly tough thing to fight over. This does happen, though. These fights happen where we question the extent to which there was capacity. And then the other is to say, hey, there was somebody else who was pulling the strings. So that's not a capacity concern, that's an undue influence concern, where they'll say, there was a caregiver, the family member who just happened to be on their deathbed, that kind of thing. And okay, thanks, Stephen. And that person really exerted a large amount of influence here. It wasn't mom and dad or whatever the case is who wrote the will. It was somebody else. And really, because they weren't in a position to deal with whatever factors are at work here, they just signed the document that was put in front of them. So sometimes you'll see this, Paul. I know a few lawyers today who are actually in the practice of videotaping their discussions with their clients, okay? Where they'll say once it comes, they'll have a whole preliminary discussion, okay? And then they will videotape that conversation. Now the videotape thing is okay. It's not, that's not your will. So it's not like in the movies where you can have a video will. You know, you watch that thing in the movies sometimes where somebody does the video will. That's not possible. But if there was ever a challenge to the written will, then you would have that videotape evidence that you could bring into court to say, look, here we are having the conversation. Here's clear evidence that whoever I'm interviewing understood what was happening. Here they are expressing their intentions. And yeah, that's it, Melanie, right? It's okay. Yeah, these are bad situations, Melanie, but they prepare you better for dealing with the same type of thing with your clients, right? And again, like I said before, you steal Melanie's story here, right? Melanie's story is a useful story for a case like this. Steal it, and it at least gets people to think about, you know, when I write my will, is it going to stand up to a challenge? Okay. All right. Are we good with undue influence and capacity? Does this make sense? We're going to talk more about capacity later on. That's specifically our topic for later on this morning. Okay. Yeah, if you, that's your holograph will grant, right? As long as you got it signed, you're okay, right? Okay. No, so very explicitly, Paul, and we're going to talk about that again this afternoon, very explicitly, powers of attorney cannot alter testamentary documents. Okay. All right, so the next source of possible challenges is going to come from family law. So now we have beneficiaries, heirs, family members who are dissatisfied with the will, and they say, hey, I should have gotten this, whatever it is, if we used family law principles. Now, the ability to render a challenge like this varies by province. This is always going to be available to some extent, okay? So generally speaking, a spouse, a surviving spouse or common law partner should be left in a similar position to that if you had the relationship break down. So if that's not true, that person would launch a challenge as it concerns the estate. Okay, is everybody with me there? Now, a similar circumstance arises where we have an ex who was promised something in a support order. Okay. And then we also want to make sure that any dependent children are taken care of. And that is generally the first priority. So if we have a case where somebody left money to somebody other than their dependent children, and the dependent children would not have enough resources to see themselves through to adulthood, then we would have, or to independence, then we would have a potential will challenge. Okay, that's good. And Melanie, that's the case that I had sent you before. Melanie had posted a question on the forums before about sort of the validity of will challenges. Okay, which I find now an ironic question, Melanie, considering that you saw it as necessary. And this is good, right? But you saw it as necessary to videotape your discussion with your dad about his will, right? Which, I mean, clearly you knew that a challenge was possible there, right? You knew that this thing with your brother could blow up. So yeah, so that's, you know, sort of your lived experience there is worth quite a bit. But when you get to see one go through the courts, no, I'm fine with questions, Paul. All right. When you see it go through the courts, then otherwise you just get me all day, Paul, right? Okay. So the, yeah, this case that I had sent to you on the forums, Melanie, was a case where a girl who was not the daughter of a deceased testator, but had sort of had a dependency type of role to that person via her own mother. Her mother had sort of a, sounds like an on again, off again romantic relationship. And she was able to, at least to some extent, successfully challenge her not quite step parents' will to get some access to some of the funds. Okay, that's good. So that question of dependency, it really is kind of a moving target, and you have to look at each set of facts on their own. Okay, that's all good. Now, I will point to BC and Nova Scotia. In BC and Nova Scotia in particular, there is a statutory or a written legal obligation. It's called a moral obligation. And it says you have to take care of all of your children, even if they are financially independent. And this can lead to some really difficult outcomes. Doesn't necessarily have to be even, Paul. It can be an uneven distribution, but there has to be some effort at, let's say, equality between the three kids. So if you had three kids in BC and you're going to leave a much smaller gift to one of the kids, you would want to write in your will why you're doing that. You would say, well, I already helped them make a down payment on a house. I paid for their university education. The other two kids, I didn't do those things. So that's where you'd want to make sure that you've addressed that. So it depends on the circumstances. Shauna, I can't remember exactly how the BC laws are written around this, but it's a good question in that you might not have that obligation to your stepkids. However, I know I've seen some common law in British Columbia where stepkids would have some relationship here or some rights. Okay, if they were adopted, then yes, then they're kids, right? So once they're adopted, then they're kids. So that's where you get into challenges here, Shade. That's exactly where this leads to problems because there is no exemption for an estranged child. So you have three kids, but one of them you haven't seen in a decade. You with me here? In British Columbia, that child, when you die, could still step up and say, hey, look, I know I haven't seen mom and dad in a decade, but I'm still entitled to some of that money. Okay. That's good. And they will have a valid argument. They will get something if there was nothing left for them in the estate. Okay, that's good. Do you see why now, when I talked earlier about the lawyer not being comfortable writing a will where they only have a 3-day turnaround? Do you see why the lawyer really wants to make sure that they are gathering all the information, writing a robust will, a will that's going to stand up to challenges? I don't know that term, Bev, detrimental reliance, sorry. I've not heard that term. I assume that's something that you've come across in an estate law case. It's not a term I've heard before, but if you want to throw it out there, sure. We can talk about it. Is this the idea that somebody would, like a drug addicted child, would take your money and spend it? Is that what you're thinking here? I don't see any Canadian reference to detrimental reliance. Where'd you come across it, Bev? Oh, there, Gowling. Not necessarily equally, Mark, but there'd have to be, you'd want to explain. Remember, I just mentioned that, Mark, you might have been away for a second, but you want to make sure that you clarify why you're not doing an equal distribution. Okay, so you paid for one kid's tuition, or you help one make a down payment or something like that. Okay. So I'm going to show you something similar to that, Bev. Okay, hang on to that thought. All right. Yeah, I see it in a common, or in a property context, property law context, but I don't see it in an estate law context. Okay. Yeah, all right. I will show you something related to that. Now I gotcha. All right, the next set of challenges that we can look at relates to the question of intention. And I already gave you an example of where intention is a problem. And that was, I have an old will that treats 3 kids equally. Okay, and then a newer will that only deals with 2 kids. I can see why, having a quick scan of it. All right, so we have a newer will that only deals with 2 kids. Okay, and the third child says, hey, look, it was the intention, it was whatever mom's intention that I get something. It's right here, it's clearly expressed. Or the child might rely on a verbal promise. There could be a bunch of different reasons why we would question intention. So the child says, look, all along, mom always showed an intention to leave me in the will. It's weird. It's an oversight, a drafting error, an administrative problem. The lawyer messed up, whatever it is. There's going to be something here that leads to an intention problem. Okay, that's good. So maybe, Bev, that ties into your comment right here. You with me there? Okay. Yeah, it does not have to be kids. I agree with that. However, it's most often kids where you're going to have that verbal promise, right? Although it happens with business partners, doesn't it? You sometimes get business partners who have those verbal promises to one another, and then a will doesn't follow up to match that. Okay. Just a second here. I think I messed something up. All right, the next one is probably the most difficult of the scenarios we look at. This is a public policy challenge. And no, you don't need, so a contract, you know, this thing, Esther, right? A contract can be verbal, a contract can be written. But when we rely on verbal contracts, then evidence is a problem. So you don't necessarily need witnesses, but that would be helpful, okay? Just like a videotape would be helpful, right? Okay, so we might get a public policy challenge. So public policy is where we don't necessarily have written legislation, but there is some reason we won't carry out the will. And it's that it's offensive to public policy, that the law shouldn't allow this type of activity to happen. There are three common public policy arguments you'll see made. One is that you cannot, you or your heirs cannot profit from the proceeds of a crime. Okay, so that's a public policy argument that we sometimes see. It's not that common with wills. It's more common with life insurance beneficiary designations. Okay, and the specific example where you'll see this done is, and these are tragic, just terrible circumstances, but where you'll see this done is in murder-suicide cases where the husband, I'm going to pick on husbands here, the husband kills the wife, then himself, okay, and his kids are his beneficiaries on his life insurance policy, and the life insurance policy is more than 2 years, so we don't get into a suicide exclusion problem. Yeah, I'm going to talk about that one, Paul. Yeah, okay. A Nova Scotia case, in fact, Paul. So his kids are his beneficiaries on a life insurance policy, and the insurer now may not and can get away with pay the death benefit to his kids. Okay. That's your most common example of a challenge to not necessarily a will, but to an estate based on public policy. Okay. Now, another one that we've seen, Paul is right to refer to here, is funding of terrorist activity. And, oh no, I don't remember the case name, but anyways, we had a Nova Scotia case about a decade ago, about 2010. And what happened here was this guy, not terribly wealthy, but sort of modest net worth. He left $1 million to the National Alliance, which at the time, I don't know if anybody follows such things, but the National Alliance was a US-based white supremacist group. Okay. And they were not listed as a terrorist organization in Canada. So the way this works in Canada is the criminal code identifies the criteria for terror groups, but then you actually have to show up on, oh, I don't remember now, I think it's RCMP maintains the list of what those terror groups are. And National Alliance was not on the list of terror groups, but they were unquestionably involved in terrorist activity. There was a whole bunch of like fire bombings of synagogues and that type of thing, where synagogues and mosques, where they were clearly involved and promoted that activity and so forth. But they weren't a terror group in Canada. That's good. So what ended up happening is the gift to the National Alliance was successfully challenged or successfully blocked in the Nova Scotia Superior Court. Now, the criticism here, and this is sort of an awkward thing, I think we all agree this is morally the right outcome, right? Nobody wants $1 million going to an organization like this. The criticism here is that if he had made this gift the day before he died, it would have worked. So basically, because he tried to do this in his will, he was unable to do something that he would have been able to do while he was alive. Okay, so you're right, Shauna, there's nothing in the contract document that prevents it from paying out. You with me there? That's why it's a public policy provision. That's exactly what that means. That public policy provision means that we don't actually have to put that in the contract wording, that the insurer can rely on this sort of ancient public policy concept where people cannot benefit from the proceeds, or people cannot benefit from the proceeds of a crime they have committed. Okay. All right. So yeah, that's why I say it's not necessarily written legislation, or in the case you're asking about, it's not necessarily in the contract. It does not have to be. Okay. Yes, that's true, Todd. The wife's policy would pay out. It wasn't her actions that caused this to happen. She's not benefiting, or her heirs are not benefiting from the proceeds of a crime she committed. Okay. Yeah, but you see why, Esther, the whole idea here is to prevent people from doing this specifically to enrich their heirs, right? So the idea here is we say we don't want people motivated by having a bunch of life insurance and then using that to solve their own financial problems and leave their kids with no parents but a bunch of money, right? I don't know, can give you a list. Like this is something that legitimately happens. My wife, for what her, like, I don't know, she loves to subject me to these murders, these true murder stories, and they're full of these kinds of stories. Okay. All right. That's good. Okay. I told you the story before, Esther, about the guy that I know who disappeared after having applied for the maximum amount of life insurance he could buy without financial underwriting, right? It is, Roxanne, never prosecuted, but it is a crime, yeah. Okay. I think it still is. I don't update my criminal code all that often, but yeah. Okay. I believe you're correct, Nicole. Yeah. Okay. And then our third public policy provision we've run into, as long as it's been enforced for more than 2 years, Todd, but here we're running into the public policy provision, not the suicide provision. Okay. Okay. Not if you don't kill someone. What? Still could be a crime. Okay. Attempted is part of many, many crimes, right? So yeah, now on that note, the crime that's being prosecuted here really is the murder part of it, right? So the whole the whole thing is the crime. All right. Okay. So my third is racist wills. Okay. And we had a couple examples of these where we have a will that explicitly doesn't leave money to somebody because they married. And actually the most recent example of this is an Ontario example where a guy from Jamaica who had 2 daughters specifically wrote a daughter out of the will because she married a white guy. Okay. Now that being said, it turns out that as much as we know that's what happened, the will never actually made that comment. So the Court of Appeal ended up overturning it. Everybody knew that that's what he had done, but the will never said that I'm writing my daughter out because she married a white guy. It was just what he had told his daughter and her sister and the family priest and somebody else. Okay. So that being said, that's been a public policy challenge. Yeah, absolutely, Stephen, that can be challenged. Yeah, because what you're doing here is you're creating a prohibition on that person's ability to really carry on their own life in a perfectly legal way. Okay. So I can't use my will to impose a restriction like this on somebody's life. Okay. So that's been the most common example, is these racist wills. All right. So the problem though, Stephen, is that if we allow that kind of thing to happen, right, what you're doing is you're using the government, you see that? You're using the government to really enforce a charter restriction, right? So under the Charter of Rights and Freedoms, I have the right to get married. Agreed? And I should be able to marry anybody I want with no outside discrimination on that. Yeah, that's what really happened in that case, Bev. If it had been in the will, it would have gotten overturned. But in the end, his will succeeded because he didn't actually write in the will that was the restriction. Okay. Yeah, and that's exactly what ran into a problem here, Paul. Okay. Yeah, that's the argument here, Stephen, is that ultimately you're using the government to create this outcome. And to what extent should the government be involved in creating these, whatever, these funding of terrorist activity situations or these racist situations? Okay. Should your tax dollars go to restrict people's charter rights? Okay. Right. So we did talk about that a little bit earlier, Paul. If you have an incomplete will, then the courts will look at that and say, well, how close to complete was it? Was it enough that we can establish intention? Was it enough that we can believe that it was you that made it? And the courts have accepted those types of things. Okay. But that's just because he didn't like her, Nicole, right? Is that because, so, or is this like a gender, it's so specifically because of, now that would be the question, Nicole. Did he write it down somewhere that if my daughter marries a woman, that I'm going to cut her out of the will? Or is it just that when she, and I know that the outcome doesn't really, it's the same either way, right? But that would not be permissible. But what's fine is she got married, and everybody knows, it's much like my racist will argument, right? Everybody knows that he cut her out of the will because she married a woman, but he doesn't write that into the will. Well, then you don't have a public policy argument. Okay. You see that? So I really, the courts will generally in that case, at least if we follow, oh, and I can't remember the name of this case, I apologize, but Smythe, I think, if we follow the sort of line of thinking we've seen in the courts here, we need to see that written into the will in order for us to have a successful public policy challenge. Okay. So yeah, everybody might know that was the case. That's not helpful. Okay. All right, so that's a sample. There are other reasons, but those are some of the common reasons we see wills challenged. Okay. Well, that's what would create that court ruling, Esther. Okay. So everything I'm showing you here is based on court rulings. Okay, these aren't sort of arbitrary things I have made up. These are all items that there's some precedent behind. Okay. And we're just not surfing around on Canly to look at all those precedents. All right. Yeah, I mean, it's a fair argument, Roxanne, and who knows what the right outcome there is. Okay. Yeah, that's true, Paul. There was a BC case, and that ties back to what I talked about before, Paul, the case you're referring to, where, yeah, they just left stuff to the sons, nothing to the daughters, and it was a BC case. So the daughters were able to successfully challenge it to come back and say, we should have gotten something, but they really relied on, I showed you that before, the moral imperative that you have to support all your kids in BC. Okay. All right. Yeah, and the reason Paul knows that case is because BC and Nova Scotia have very similar laws that way. Okay. All right. That's all good. Yeah, I remember that one was in CBC or CTV or whatever, Paul. It was interesting. It's funny what creeps into the sort of mainstream news on that front. Okay. But if you subscribe to, yeah, and that's not unusual, Esther. There's quite that right. It's called the right of primogeniture. There's a lot of parts of the world that have that still as an unwritten rule, and a small number of countries that still have primogeniture as part of their written law. So when you have clients who come from other parts of the world, you may have to negotiate how they're going to deal with that primogeniture. Okay. That's the same actually in Japan. Until about a decade ago, Japan had written law to affect primogeniture. Okay. Right. Okay. Yeah, that's true, Paul. That case was a case where mom and dad thought that daughters should just get nothing. Okay. Now, I just need to take a minute here to talk about multiple wills. So to this point, we have really treated this as if you have one will, but there are some cases where you might have more than one. We did talk about, didn't I draw my little BC and Alberta map last time? So there are some reasons to have more than one will at a time. Now, if you're going to do this, it must be carefully drafted. The wills, both or whatever, all must be carefully drafted so as not to revoke one another. Okay, but you will see this. And we talked about this before. This might be necessary where you have real property in more than one jurisdiction. Okay, now you don't necessarily need multiple wills there, and a lot of lawyers will say, no, just we're going to work with one will. We'll just make sure it meets the criteria for both jurisdictions. The more common one that you'll see is for owners of successful family businesses. So it's very normal to see something like this. And this is primarily in Ontario and BC. I actually don't see it done that much in Nova Scotia, although it might happen there. But the notable thing with Ontario and BC is both have a higher probate fees, right? Around 1.5%. Ontario is 1.5 and BC is 1.4. And so what you'll see done here, let's say I have somebody who dies, and will number 1, we're going to probate, okay? And will number 1 has the house, the non-reg investments, it has vacation property, it has whatever, the cars, rental properties, all that kind of stuff. So that will get probated. We're going to put that will through probate, and you're going to pay your probate fees on it. Okay, but will number 2, is going to include only the shares. Either or, Paul. Yeah. So a jurisdiction could mean different provinces. It could mean different countries. Okay. So will number 2 is where we're going to have shares in the family business. And that's the only thing that's going to be in there. And the reason that we're not going to probate this will is because these are going to be dealt with by some other document. So really, the will sends you to whatever other document, the unanimous shareholder agreement or a buy-sell agreement. Some other document. There's going to be something here that's going to essentially, I don't want to say override, that's not quite the right word, but something that's going to replace the requirement to distribute these shares via the will. So we're not distributing the shares because of what it says in the will, we're distributing the shares because of what it says in this other document, and therefore there's no need to probate this will. Is everybody with me here? Now, the courts have taken a dim view of this, and we've seen, especially the Ontario courts, try to challenge these, but still today it's a valid strategy in Ontario at least, and I'm not aware of a challenge in BC by the courts, but yeah, the Ontario courts have unsuccessfully tried to challenge these, or really the Ontario government, I should say. Okay. Less likely with a partnership, Paul. You could do it with a partnership. It would depend how the partnership was structured. Okay. Yeah, it's not impossible. All right. Yeah, but the USA and the buy-sell, those are your legal documents, Todd. Yeah. That's good. Those are just not documents that have to go through probate in order to be executed. Yeah, so you could have a partnership agreement. The partnership agreement essentially fills the same role as the USA. Yeah. Okay. All right, any questions there? All right, that's it for wills. Are there any wills questions in general? Does everybody feel comfortable enough now that you happily go sit down with a client and write their will for them? No, that's a trick question. All right. Okay. That should be the answer here. I'm hoping everybody does feel uncomfortable enough that you recognize exactly why we need good drafting lawyers writing these wills. Okay. Thanks, Paul. All right. That's good. And I would suggest if you don't recognize all the things that can go wrong with a poorly done will, and sometimes even really good wills have problems with them. But if you don't recognize all the things that can go wrong, you've really, I think, not been paying attention for the last hour and a half, right? I think it's a little early for coffee still, Todd. All right. I have not seen Happy Feet 2, Stephen. All right. My grandkids are still a little young for full-length movies. So. Okay. So I shouldn't say that, actually. I guess it depends what the movie is. There is a very narrow set of movies they're happy with. Okay. So nice. Okay. So we're going to look at the power of attorney. We'll introduce the power of attorney, and then we'll take a coffee break. Okay. So power of attorney is going to allow an attorney, and this is the person named in the POA document, not a lawyer. We don't mean lawyer here. This is a legal position where you're simply having responsibility for somebody else's affairs. And they're going to exercise some sort of authority on behalf of a grantor. That's the person who wrote the power of attorney. Okay. Or the person who signed it when a lawyer wrote it. All right. Does that make sense? Now, on the next slide, we're going to talk about the limitations the attorney has. But when we think about an attorney, this should be somebody you trust. This should be somebody who has at least a little bit of financial wherewithal. They don't have to be an accountant or a financial planner, but they should have at least some I spelled that wrong, but whatever. They should have at least some ability to manage financial affairs. And generally, it should also be somebody local to you. Okay, you don't want to name somebody 3 provinces over or somebody from a different country as your attorney. That's going to create a large amount of administration for that person. They may even have to post a bond with the province where the attorney is, or the power of attorney document is executed. Okay, so the attorney or the authority that they're going to have will be defined in the POA document. Yeah, absolutely, Bev. And we talked about that briefly with executors last time, right? So if you wrote a document that named an attorney, but the attorney wants to decline it, they can absolutely do that. Again, as long as they do it early in the process, right? If they sort of get 3 months into it and they've done a bunch of POA work and now they say, wow, this is terrible, it's probably too late to reasonably back out at that point. If they're going to back out, they would really have to essentially almost like close out an estate. They'd have to demonstrate to the courts that everything they did along the way was above board. Okay, yeah, exactly right, Paul. Yeah. Okay, so the authority is going to be defined in the POA document. Okay, so is it simply administrative? Do they have property rights? That is, can they buy, sell, dispose, mortgage property for you? That has to be explicitly defined in the document, or they don't have those rights. Now, many of you on the call have internal POA documents. Is that fair? Many of you on the call have, well, so that's what I'm really asking about here. Yeah, so I can go into my bank, for example, and I can get my bank to set up a power of attorney that deals with the bank accounts I have there. Is that a fair comment? Investment dealers typically have that as well. Most credit unions have that. So that power of attorney will typically give you rights over the financial accounts at that institution. Okay. Yeah, and those are two different documents, Melanie, right? So your POA for healthcare is a separate issue from your POA for your financial affairs. Okay. So there are those internal POA documents, and they can be useful. I think they're a nice thing to have. So internal POAs, where, for example, I have a bank that gives POA for all the accounts at that bank. Okay, that's easy enough. No, that's what you're talking about here, Paul. So if I go to my lawyer, you with me here? I go to my lawyer and I get my lawyer to draft up this document for me. I now have a power of attorney. Okay, and that power of attorney, I can take it to all the different places that I do business, or that my spouse or whomever, the grantor, did business. So I can take it to our utilities companies, I can take it to the bank, I can take it to investment dealers and say, here's the document. And it's much like an executor getting a will accepted by those places, that now you're going to use that to carry out business on that person's behalf. That's good. And it'll be a notarized document. It'll meet all those same criteria. It really looks very much like getting a will accept, or getting the will to give authority to the executor to make decisions. Does that make sense? So you can have that internal POA, or you can have, oh, I understand what you're asking. Okay, sorry. So yes, I can, okay, this is a tougher one. There is an office in every province called the Office of the Public Guardian and Trustee, or some version of that. And you can appoint the public trustee to do the attorney role. However, they're not going to do a great job of it. Okay, and really what they're going to do is the absolute bare minimum, so that you don't starve to death and your house doesn't become uninhabitable. Okay, it is like many other government agencies, overworked, understaffed, all that good stuff. Okay. Or if you had somebody who had money, they could actually use a professional attorney or a professional trustee service to fill this role. Okay, but you typically have to have some assets to do that. Okay. Now, generally speaking, we have two kinds of POAs. We have the general power of attorney, and this is just administrative, and we talked about this once before. This is administrative. It basically takes effect now and has effect until any of several things happen. The grantor dies, that's going to end this document. the grantor loses capacity, although I'll talk about the exceptions to that in a moment, has effect until the grantor, if they have capacity, revokes the document, or there might be a built-in expiry date. Okay, does that all make sense? So when any of those things happen, that document would end. Now, the other kind of power of attorney, the one you're probably all more familiar with, is that, Tricia, right? The enduring or springing power of attorney. It's our second kind. And this document is designed for our estate planning needs. So this is really more of a contingency or medical type document. The idea here is if the if the grantor loses capacity, and generally speaking, the test is written into the document. Okay, so my wife and I have powers of attorney on one another, and our powers of attorney say that two medical professionals who are not family members, who are not my family members or her family members, have to agree that capacity is lost, and that would cause the document to spring into effect. Okay, so if the grantor loses capacity, then the attorney has whatever authority is defined in the document. Okay, that's good. Now, I actually think for a lot of young people, this is a far more important document than a will. Okay, you've got a 22-year-old who is not married, has no kids, none of those types of obligations. That person should have this document. A will is nice. It's going to make life easier if that person dies in an unfortunate accident. But what's more likely to cause a bunch of problems for their family is if that person ends up in maybe they have a bad cycling accident and they end up in a medically induced coma for a period, or something like that goes wrong, or maybe they have a temporary psychiatric issue. And that's where this power of attorney can be quite helpful for their parents or whoever it is that would be managing their affairs. Without that type of document, your requirements to get guardianship, what we call adult guardianship, are incredibly onerous. Okay? Has anybody ever dealt with, Lonnie, didn't you have this? The adult guardianship problem? Yeah, I thought so, Lonnie, right? So and it's difficult, isn't it, Lonnie? It's intentionally difficult. It's expensive, it's time consuming, it's emotionally draining. This is why you have a power of attorney, because it gives that ability for somebody else to step in and just bang, have the ability to manage everything. Go ahead, Stephen. Yeah.
Yeah, I'm just curious with this. Obviously, I'm not even 30, so I deal with a lot of young adults, and with Sun Life, we got that whole financial pyramid thing, and we always discuss and bring up the will and power of attorney as a very important part of the financial plan. So I always kind of rough this one, but I need a better grip on this thing, and I don't know if Lonnie can speak to it, but if I'm sitting down with a young adult and I say, yeah, you know, the will might not be as important, but that power of attorney, I do always express it and just say, you know, what if you were to become unable, whether it's you were sick to some point or whatever, physically not able to do these things, this is why you need it. But what is this, like, having to apply, and what are the costs, and what does it really look like?
Yeah, so, and Lonnie, go ahead and chime in. And I would suggest here one thing, Stephen, that you probably already do that kind of echoes this. and I think we chatted about this once before, I'm going to assume with your young adult clients that your risk management discussion focuses more on disability and critical illness insurance versus life insurance. It's the exact same conversation, right? So in the sense that you're managing the same risk here, right? But yeah, if you lose capacity and have no POA, okay? And I know the Government of Alberta website is really good for this. Actually, there's a Government of Alberta website that asks exactly this. And what it really shows is if the answer to that question is yes, so it's like a flow chart. And it says if the answer to that question is yes, you have a power of attorney, then you basically stop there. You're done. If the answer to that question is no, there's no power of attorney, there's like 30 steps that follow. Okay? So just that alone can be useful for sort of demonstrating this. But essentially what happens here, so you lose capacity, have no power of attorney, and now you still need your bills paid, whatever, your mortgage renewed, access to your emergency funds, whatever. Yep, perfect. Taxes filed. Although to be fair with taxes, if you have a medical problem that's caused a loss of capacity, you can apply to CRA to give an extension, but easier to file them. Okay, so all that stuff still has to be done. Okay, auto insurance renewed. Okay, bank accounts dealt with, minimum credit card payments made, all that kind of stuff. Okay, there's 1,000 little things that you just don't think about until just go 2 months without ever logging into any of your online accounts. See what your life looks like after that. Okay, so you still need all this stuff done. Right, that's the problem here, Stephen. So essentially what happens here is the courts assume that anybody who would want to help with this is doing it to steal your money. Okay, that's really how the law is written. And if you start with that as your kind of baseline understanding, you're going to be in good shape for thinking about how difficult this process is. So now your parents want to keep you sort of afloat, keep all your stuff from lapsing, keep your car insured, keep your house insured, keep your bank accounts operating, whatever else. Okay, so they apply for adult guardianship. And again, it's the same assumption. The courts assume that the reason you're applying for adult guardianship is to steal all your money. That's good? Yeah, 100%, Andrew. This is not a problem that's limited to young people. Absolutely the same thing with husband and wife. Once again, we have that same assumption. The courts assume that, yeah, same problem, Paul, right? It's a trust issue. The courts assume that the husband is applying for guardianship to steal all his wife's money, Andrew. Okay? That's good? Yeah, now, Lonnie, your circumstance, as I recall, was quite a bit messier than this. There was an attorney, and the attorney was legitimately stealing money from the, right, was taking advantage of their position as an attorney. And you had to apply, if I recall, for adult guardianship to get the attorney moved on, right? So, yeah, go ahead, Lonnie. Yeah.
No, I mean, the situation was a mess to begin with. So make sure you're telling your clients to get all this stuff done like long before they ever think that they need to, because if you don't get it done while you can show capacity, it can be a huge problem later when somebody like my father, who was the person in question, did not have capacity but had power of attorney drawn up, will drawn up, new wills drawn up, and his wife cut out of everything by a family member. So don't mess around with this stuff.
Yeah, and again, steal Lonnie's story here, right? Get it done in advance. And that goes back to, picking an attorney of trust, getting it all set up well in advance. Same as your will, right? So yeah, when you apply for adult guardianship, basically what's going to happen here is you provide a full financial accounting of your own situation. You're not applying, you're not giving the, and this is a publicly available document now. And to me, that alone is motivation to get this squared away in advance, okay? Because what can happen now is you have the parents who apply for adult guardianship, they give that full accounting, then you have somebody who's making an accusation in the sort of ballpark of what Lonnie just talked about. They can go to the courts and they can pay their 25 cents a page to get all the information that went into the original guardianship application. That's good. And that's not the only thing that happens there, but that's the sort of most onerous step that shows up. Okay. Yeah, and the weird thing here, Roxanne, is how this whole thing entirely circumvents privacy legislation, right? This is something you're sort of willfully exposing yourself or your family members to that. Well, we'll take a coffee right away here, Paul. All right. Yeah, I mean, Lonnie's case is useful here, Stephen. In Lonnie's case, the power of attorney was sort of done, and Lonnie will correct me here, but the power of attorney was done just at the last minute. Like once they realized there was a problem, then Lonnie's dad named an attorney, and that attorney was not the right person to be doing the job. That's good. And ended up dipping into, yeah, which really put Lonnie in a position where he had to apply for the guardianship, the adult guardianship order. So now, in the eyes of the law, when Lonnie gets adult guardianship over his father, he is the parent. He is legally in the same position as a parent would be. That's good, which includes both your responsibilities and your legal obligations, okay? All right. Okay, any questions there?
Jason,
Go ahead, Andrea.
so an enduring or springing power of attorney, that's commonly not used.
That's the one. Okay, so if you send your client to a lawyer today to get the whole package done, Andrew,
Right.
your client is going to walk out with their will. They're going to walk out with the enduring or springing POA.
Okay, so
They're
that's
going to walk out with the healthcare directive or whatever that document is. Yeah, so it's not commonly used, thankfully, right? That's true, but that's the one your client will have.
So there's two different types of power of attorney, though, isn't there? There's medical, obviously, and there's financial. But is there not two other different types of power of attorney? There's
Right, so that's the general. So I have that here, right? So that's the two kinds of POAs on the bottom left corner. You see that?
and then the spring.
Yeah.
I think recently we had a client, like we send it up to our legal department and they kind of interpret it and then they do, we tell us what to do. So I think we've had it recently though, where we've had maybe a general only. Is general not as, you don't have medical and financial, is that correct? Or what's the difference between the two?
So the general is really just administrative. So my wife and I used to do this. We used to do a general power of attorney. We were both in the military at the same time, right?
Okay.
And this was in the days before you had ready, like when one of us, and especially in her case, when one of us was deployed to an interesting part of the world, you don't have daily access to email, you don't have fax machines, you just can't get documents done, right?
Mm-hmm.
So before one of us would go wherever we went, we would sign this document that says, okay, for the next 12 months or whatever period, I am giving this other person general power of attorney. It's going to capture all of these, this ability to deal with my affairs. In fact, I remember one specifically, my wife was gone when her mortgage came up for renewal. So we had to make sure that was all addressed in advance, right?
So, general could be used more often. I'm thinking more for, people going to Florida for 3 months or.
Yeah, now honestly, I wouldn't be as concerned about that today because you have like that person who's gone to Florida for 3 months, they can still e-sign documents, right? They can still take care of a lot of the sort of routine stuff that you would be doing. I know you get into some questions around account management for investment accounts, Andrew, right? That you probably can't take instruction from a client while they're in Florida as it concerns an investment account.
Mm-hmm.
So that might be a place to use that document. And in that case, you're probably just going to do a very narrow power of attorney. That's where I would suggest you're better off doing the internal power of attorney, just using the thing that Investors Group gives you, right?
Yeah. Yeah.
Because
Has that changed? I thought there was a change with the MFDA in general, I guess, about say someone's vacationing for 3 months in Florida, about transactional. Has that changed at all in the last year or two?
it could be, honestly, I don't read every MR that comes out of MFDA, Andrew. That's
I know we used to not be able to even do a transaction or a switch or anything until they were back in Canada. Is that correct? And then now I think that's changed somewhat, but I'm not sure.
could very well be the case. Honestly, I have my little compliance bugbears, but I don't pay attention to every aspect of that. So I think, Cam, I answered your question. So it's not necessarily that one is better, but the enduring power of attorney is the thing you're probably more concerned with. That's the contingency document. Go ahead, Stephen, and then we'll take a break. We'll take Todd's coffee break, and then we'll be back. Yeah, go ahead, Stephen. Yeah.
I guess with in terms of investment direction, transactions, trades, if you've got an LTA on file, if a client called me and said, "Hey, can we move these funds?" Am I supposed to ask, "Are you currently in the province of Ontario?"
So that's really a question for your compliance department, Stephen. But yes, to some extent. And again, I don't know what the MR currently says on the MFDA side, but you do have to take reasonable steps to make sure that, because you could end up in violation of securities law for taking trades that are
Right.
offside for that purpose. But again, I don't want to comment. That's a question for your compliance department.
Okay.
Okay. Yeah. Yeah, that's a difficult one, Shauna. And there's no way, honestly, for you to know that, right? The real thing to do there is to talk to the grantor and see if there's any evidence of revocation of that document. The problem is, does the grantor have capacity, Shauna? Right? And that's why, to Andrew's comment, that's why it's not you that's going to judge whether the POA document is valid. You're going to send it off to your legal department, and they're going to make that call. Okay. All right. Any questions there? It's a good time for a break. We're a little past, I apologize. I've got nice 9 minutes past. Take a 15-minute break, and we'll resume at 24 past. Okay. Thanks.